Hello everyone, we're just waiting for everybody to arrive and we will start the webinar in a couple of minutes. Thank you. Okay. Kia ora everyone, and thank you and welcome. Another good to know webinar from Healthcare Plus. I'm Alan Sharp and I'm your host for this evening. And I'm excited to be joined by Carissa McKenzie and Natasha Taylor from the Public Trust to talk about wills and EPAs. We've had a partnership with the Public Trust for a couple of years now to provide our members with lots of useful information, tools and resources about the importance of getting a will, and more importantly, to give them access to their wonderful online wills and EPA tool, which makes wills easy and affordable and super convenient. Plus, we also have a special member-only discount too when you make a will online with the Public Trust. Today, so tonight's speakers are ideal to answer that important question of what happens if I die without a will. And we'll cover that off along with many more of your questions that you asked us over the last couple of weeks. As always, we've been inundated with questions from you, and the session tonight will be a little bit of a presentation to begin with from Public Trust. And then I will ask a series of questions that you provided us pre the meeting. But however, to do that, I just want to go through a little bit of housekeeping, because you can also, if something comes up during the presentation, you can still ask the question too. If you go to the bottom of your screen, you will see that there's the ability to do either chat or a question and answer functionality. And I'll be monitoring that during the presentation to make sure that I pick any of those questions up. If we've got time at the end, we'll ask them. Otherwise, if we haven't got time to answer all these questions, and there are a whole load of questions that we got from you prior to the evening, we will be doing a bit of a Q&A blog post this webinar, and we'll be sending that out to you along with a little bit more information. But before we start the presentation, I just want to do a quick poll, and excuse me if this doesn't kind of work because it's the first time we've ever done it. But I just would like to ask a quick poll before we start. Can you please just answer whether anyone who's out there has got a will or hasn't got a will, just so that we can see what the state of play is amongst our participants. I'll just give you a couple of seconds to do that. Okay, so anyway, that's enough from me. So I'm going to hand you over to Carissa and Natasha So kia ora, Carissa, Natasha, welcome, and over to you.
Thank you.
Thanks, Ellen. Now I'm going to cross my fingers and hope technology is going to work. So do you have a will? 34% have one. That's fantastic. 60%, 66% don't. So this is a great opportunity to talk and hopefully respond to your queries that you have. Now I'm just going to hit share screen and I'll hopefully get the nod that we're on the right one. Ellen, if you just give me the thumbs up that we can see it. Fabulous. All righty, so we're off. Okay, so thanks. As Ellen said, I'm Carissa. I'm a principal trustee from Public Trust. I'm based in Kapiti. You can see the Kapiti Island hopefully behind me. And Natasha is one of our wonderful senior trustees in the Christchurch team. So let's jump straight into this and just start off with a reflective question. How would you feel if maybe you're in a situation of a blended family or you know somebody in a blended family? If you feel, what would happen if your partner passed away and you were told that you had to pay out your partner's children a financial amount in order to remain in the home that you shared? That may be one scenario that you or a loved one has faced if there isn't a current will in place. So I'm going to talk to you a little bit more about this later, but first let me share with you a statistic that extends on to Ellen's question. So from our research, approximately 50% of New Zealanders don't actually have an up-to-date will. So they may have one, but it's not up to date. And without a current will, you can leave your loved ones facing legal and financial difficulties. So what we're going to go through today is Natasha's going to, I'll flick over to slide 2, hopefully. That works. She says. No, we're getting a no there. Here we go. Oh, learning as I go. Slide 2. So Natasha's going to give you a brief overview of Public Trust for those of you who aren't familiar with us and some of the things that we do. And then I'm going to talk to the common questions that I've been asked. I've been with Public Trust for 27 years this last month. So I've been privy to quite a few questions from a variety of people. That includes what happens if you don't have a will? When should you consider updating your will and what should that comprise of? Who can challenge your will? How can you look after your loved ones through your will? And then Natasha's going to briefly share the steps to updating and writing a will, particularly with our new online functions. And then I'll close off with what happens with decision making when you're alive. So you've not passed away, but there's somebody needing to make decisions. And as Ellen mentioned, we'll kick into a question and answer session from the questions that you submitted prior to the seminar. So all going well, I'm going to hand over to Natasha now.
Brilliant. Thank you. Thanks, Ellen and Carissa. So first of all, let's talk about who we are. So who is Public Trust? So let me rest assure you that actually we have been here for 150 years. So you have some fantastic support here with us. We have 400 people across New Zealand who are more than happy to support you with your legacy. We're getting ready to celebrate our 150 years this year. We are in the midst of it, and we're looking forward to the next 150 years. So that means for us, we've had 150 years of conversations with our clients, with our beneficiaries, with our families around the importance of having a will in place and what that would mean for them. We however, not only support around wills, we do also support around enduring power of attorneys, and that's something Carissa will touch base with later on. And we also have another arm that deals with the conservatorships, so helping vulnerable New Zealanders who can't help themselves. We have a huge charitable trust, and with that, we also manage other charitable trusts. So there is a long arm that actually Public Trust extends to. When we're looking at wills, an example of this is to support you with drafting a will, because this will be your voice when you're no longer there. So we'll kind of talk to you and we'll prompt you around thinking about what your important assets are. And because when it goes to estate administration, this will be your voice when it's needed. So it's important that we support you to have a really good conversation. Enduring power of attorneys, as I said, and Chris will follow on from this is your voice when you are alive, when you're living, but you don't have the capacity to support yourself at the time. We also support around trusts, getting an arrangement in place to support families to protect their assets. So maybe putting a property in a trust and linking that with discretionary beneficiaries down the track, and our triple PR and our private manager services. So these are for our vulnerable customers. So if they have enduring power of attorneys where they nominate public trust to be their enduring power of attorneys, we support them with going into rest homes, we support them with paying their bills, selling properties, and actually working, aligning with their families to support them. Great. So if I'll flick back one, I'm going to give you a bit of a snapshot of what we do on a yearly basis. So we help 1,400 customers continue their legacies by managing their estates. We help around 7,600 people write a will and protect their legacy. We want to get that number increased. We want everyone to have a voice when they pass away. So this is our aim today, to educate all New Zealanders around the importance of having a will. We help over 2,000 people write an enduring power of attorney and make sure that they have the decisions in place for when they don't have a voice. We pay over 600 million in distributions and bequests to over 7,600 beneficiaries. And as a private manager, we currently manage the estates or the assets for almost 3,000 customers, which is massive. And under the Triple PR Act, and this is where we're nominated through the courts to support vulnerable customers, we have around 800 of those that we do support. So again, as I said, look, it is a long arm that we do support when you've got a voice and when you don't have a voice. So what is your legacy? So I guess it's just taking a moment to think about actually everything that you have, everything that you've built throughout your life. And this doesn't have to be, you know, just a financial, this could be your pets, thinking about your family. What do you think is important for them to know when you do pass away? You know, is that special pet there at home that you want to pass on to someone? Your legacy being the assets that you've built up, who would you like that to see passed to? So the friends that are now your family, the house that becomes a home, and maybe even a sports club. So any charities that you think you would like to support when you have passed away, these are the things that you do need to think about, especially when you are writing a will, because this is your legacy. This is everything that you've grown and that you've built up through your life, and this is what we want to protect and support you in protecting. Thank you, Carissa.
Thanks, Natasha. So what happens if you don't have a will? What people may not be aware is that if you have assets in your sole name over the value of $15,000, that requires a legal process that's followed in accordance with the Administration Act if you don't have a will. I'm going to give you a few scenarios because there's a lot of misconceptions there, but just to give you a basic idea, circling back to that reflective question I asked you about the beginning where it involves a partner and maybe some children. If there is a spousal partner, no parents, but there is children or other descendants, then the spousal partner will receive the chattels, 155,000 and 1/3 of anything that you have, and the children receive 2/3. So again, that reflective question on what does that look like for you and how you own your assets and your loved ones. If there's a spouse but no children, no parents, then the spouse will receive the whole estate. If there is a spousal partner and there are parents but no children or descendants, then the spousal partner gets the chattels, the 155,000, but this time they get 2/3 of the estate and the parents get 1/3 of the estate. If there's no surviving dependents, no bloodline whatsoever, or spouse or partner, then yes, everything does pass to the state in that time. So an application must be made to the court when you die without a will for getting access to the assets in your sole name so that it can be distributed in accordance with that act. Now, either an individual can do that application to the court, or you can ask Public Trust to do it, or you can get some assistance from us to do that. So what should you consider within updating your will? Obviously, the idea of the Administration Act gives you a feel for it's much better to maybe give your wishes out and set them out in a will prior. So what you should think about within your will is assets. What do you own over the value of 15,000? Is it KiwiSaver? Is it property? You might own it in a half share or a portion of a property, investments that you own, all sorts of things like that it may be. It could be business interests as well. Friends or family, who that you might like to provide for, or also who would you like to be involved in the decision making, such as guardianship for children or advisory trustees, where you might have somebody that's dependent and not able to contribute good decision making side of things and they need some help and support. Mementos, you might have items of significance. You might have something that some of the wider family have their eye on, and it might be a strong desire by many, or you've promised it to somebody. Those are important to put in your will to avoid those uncomfortable conversations or misunderstandings that may happen when you're not there to share your voice. Bequests, so that's leaving gifts or items to other organisations such as charities. Grandchildren has become a lot more popular these days to provide for them as well, or somebody that's close and of significance to you. Funeral wishes is also another thing to have a think about. It can be a really tough time when you pass away, where families are being asked lots of questions. They're tired, they're in grief. What did you want? Sometimes they don't know because you haven't expressed that to them. And so if you've documented that, that's a huge comfort to them. Purely from a statistical point of view, the top 5 reasons for updating a will is relationship changes. Just a handy little piece of information to know. Did you know that if you have not formally divorced a husband or spouse or wife, and you died without a will, that spouse would still be entitled to benefit under your estate. So another good reason to go get a will and make sure that it's kept up to date. Having children, obviously, is another prompting reason why to have them, but also keeping it up to date. People's relationships and dynamics change with their children with time, and sometimes it's important to reflect that in your will, as does your relationship with grandchildren. We see a lot more grandparents raising grandchildren, having a close relationship, or grandparents wanting to make sure that something from them is provided for their grandchildren. Obviously, significant assets is the other number 4 reason, and then the 5th reason for changing your will is the change in financial circumstances. Go back to there, sorry, jumped ahead. So who can challenge your will? There's a lot of misconceptions out there. We hear, and I'm sure Natasha would give a nod there as well, is that I'm going to object to the will, and we obviously naturally politely say under what grounds, and they may not have a grounds. There's 3 particular acts that there are other acts, but these are the main ones. So there's the Family Protection Act that says that you have a moral obligation to provide for certain people. It's not anybody and everybody, it's certain people. Spouse, children, grandchildren, in some cases parents, if it's a role reversal where they're dependent upon you, in some cases stepchildren where you've become a parent and they're financially dependent on you. So it's not like uncles and nieces and nephews and brothers and sisters and things like that. And the difficulty with that act is it just simply says there is a moral obligation. It doesn't say if you do this amount of money, that's it, everyone has to be happy. It just says there is a moral obligation. So to give you an example of a case law that this information is publicly available. So one little story I can share with you is that there was a child of the deceased was provided $190,000 under the deceased will. 3 of her children were provided a $1 million trust fund. This was of a total of a $3 million estate. The rest of it, of what was provided, of the 190 to the claimant and 1 million to her children, the remainder went to charity. Now, the deceased didn't provide for the claimant because he had a low opinion of her husband and his business acumen and work ethic. He had previously supported his daughter and her husband through an unsuccessful business venture. So he had felt that if he left any more to them than what he was doing, it was only going to be wasted. The daughter had a home with a mortgage and a modest income. And the outcome of the claim was that the court determined that a wise and just testator would have ensured that their child was at least having a debt-free home and a supplementary income. So from that $3 million estate, it was changed that through the court ruling, it awarded the daughter an additional $855,000 plus funds to clear the mortgage, and that moved the provisions for the daughter to 20% of the estate. And the court felt that that repaired that breach of moral duty. There's another act called the Testamentary Promises Act. That's a little less well known, and it also can be quite challenging under that one. So the Testamentary Promises Act is not just saying you can have this when I die, it's saying if you do this for me, you can have this when I die. Proving it obviously can be a challenge. Again, another interesting case which I find is that in 2002, an individual claimed that deceased had promised to leave his farm to her in return for assistance round the house and farm for the last 9 years of his life. The support was deemed not to be extensive, but equally it wasn't trivial. The estate was worth $260,000. The court initially, now the interesting thing with this one was in submitting the claim, the person actually falsified diary entries to produce and validate and advance her claim. So even though that person had falsified diary entries, the court still ruled in her favour, and the estate worth $260,000, the court initially awarded $30,000, but upon appeal, the court awarded $120,000 because they felt the judge had placed too much weight on her fraudulent misconduct. So even in that situation, there was provisions made through the court. Now, the other act is the relatively recent act is the Property Relationship Act. Now, that act says that if you're in a relationship with somebody, whether marital or not, there's about 8 different factors. It can be a same-sex relationship, marital or not, and there's a range of aspects which deems what is a relationship. The law with this often has to assess whether the relationship exists, and it's very broad. For example, there was a case where the court may need to decide whether the parties are living together as a couple, and there may be conflicting evidence of that. It looks at the duration and the continuous sign of relationship, the financial independence, the mutual commitment to a shared life, and whether they presented together as a couple. We've also had situations where other organisations such may make a claim or force a claim, for example, where they might feel that their person is being deprived of an asset or income if you haven't provided for them. Equally, if you die without a will, people can also claim under these acts. There was one case that went through where the claim was made to a neighbour. So there were children that were surviving the person that died intestate. There was a farm valued $1.4 million, and due to the neighbour providing meals to the deceased and including them in as a member of their family, they were actually awarded under a court ruling as well. So by having a current will, you might not stop challenges to your will, but a current will means that you've expressed your wishes relevant to your situation, and then you have the comfort of knowing that you've made the best possible provisions for the people that you care about. So when I mentioned to you, how can you look after your loved ones in your will? As mentioned before, having a current will is the most critical thing, is relevant to your situation. Out-of-date wishes can cause hurt, upset, confusion, and actually lead to a lot of family division. Flicking onto the side where I was having a bit of technical issues and now it's working. One of the critical things is making sure you have the right person as your executor and trustee. This can be a person or persons or an organisation such as Public Trust. They have the responsibility, but they equally hold the liability. They can be held financially liable for the actions that they undertake to carry out your will, ensuring that it's legally compliant. Does your appointment of who you're thinking of appointing or who you currently are appointed have the wisdom and experience, the ability to handle conflict? Do they have the time and the availability to carry out those duties? If they need some help, Public Trust also has an executor assist service where they can ask us to assist with, for example, the legal applications, the distributions and things like that. Or alternatively, as Natasha mentioned early on, we have quite a lot of people that appoint Public Trust as the independent executor and trustee so that we're impartial and professional, taking away the stress from a loved one. Funeral instructions are obviously a really important thing, as we indicated earlier. At that time of early grief, it can be very challenging to be able to make decisions, and it can be quite a conflicting emotion, worrying about, am I doing right by mum or dad or my loved one? Do you think that's what they wanted? So expressing your wishes can take away a lot of pressure in that early stage of grief. And then a professional will. Have you made sure that the will that you've written is legally achievable, signed correctly? Do your loved ones know where it's stored? Those are the really important things and ways that you can look after your loved ones upon your passing. I'm going to pass over now and flick across to Natasha, who's going to talk about the basic steps in establishing a will.
Thanks, Carissa. So, writing a will with Public Trust. So I've already discussed around our 150 years experience. We're consistently updating the ways that you can write a will. Currently, at the moment, you can do it yourself online. It's not something that you're totally alone doing, so please be aware that we are here to support you at every moment. We do have a chat box, so if you've got any questions as you go and write your will, absolutely stick them in there, and you will get support from our team. So what do you need to think about first of all when you are writing a will? So look, we've talked a lot around assets, around your legacies, but there are some other important things that you need to be thinking about. You need to think about guardianship of your children. Do you have young children at the moment? If anything was to happen, who do you want to support in bringing them up? So there is an important section around there around who you'd like to be the guardians of your children. If they're not available, will you have a backup plan in place, you know? So for example, if you put your parents in or your siblings, and if they weren't available or they weren't happy to do that, pop in a backup. Pets. Do you have a favorite pet that you would like supported when you pass away? Do you want them to go down to your neighbor's house? Would you like some funds to go with them so that they can be supported in the life that you would love them to have? Funeral. So thinking about how you would like your passing, okay? Would you like your family to have more of a direction on this? Would you like to be cremated? Would you like to be buried? Would you like to be scattered? Now, with your funeral wishes, this isn't legally binding in a will. So if you do decide to change your mind down the track, please let your family know. Put something in writing so that it's available if you did pass at a moment's notice, and they'll know exactly what you would like to do. Your executor, as Chris has said, it's important to have someone that you will trust to be your executor, remembering that you won't be here to make the decisions or the important decisions. So choose wisely on this. And it doesn't need to be a person. You can take that ownership away and support them by putting in the likes of Public Trust in as the executor. We will absolutely work with them in every line that you've directed with your will. So you could have an advisory trustee on your will, which will mean for you that Public Trust does need to make sure that they're consulting with the advisory trustee. So important again to think wisely about this. and your residue. So what residue means, it means what you are leaving. What are you going to be leaving to your family? So when we talk about residue with a will, we think about actually how we can I guess extend the life of the will. For example, if I'm leaving my funds to my husband, if he passes away, who will actually take his place in receiving the residue? Do I need to think about then putting my children in? If they're no longer there, will I be able to have my grandchildren to be able to pick up that role? So thinking about the longevity of your will, if you just put one person or one line of residue in place, what will happen if it fails? For looking at writing your will, so there are a couple of options to do. Okay, so online, as I said, great tools online. If you have a look at www.publictrust, there are fantastic tools and information there for you to support you with writing your will. If you feel that you would like some extra support, absolutely. We have branches across the country where you can come in, make an appointment, sit down. We have a really good conversation. We ask you questions you may not have actually thought about to support you with writing the will. And then what we do is we make sure that it's all legal and before you sign it, and we can keep a copy here in our branches, but you just need to let your family know that we've got one for you. Reviewing your will. So if you're doing this online, you can actually request a will review, which means that our team behind the scenes will check the legalities of that. As Carissa says, you need to make sure that this document is legal and it is exactly what your wishes are. So asking for a will review is well worth the time it takes to do that. Signing and storing a will. So you will need 2 signatures to witness your will, not beneficiaries and not executors. So someone who is independent of that will need to sign. Of course, along with yourself, they will need to witness your signature. And remember to review your will, okay? Life insurances, for example, things change. Are you planning to get married? If you're planning to get married, put your will in contemplation of marriage. If you are divorced, think about actually who needs to be removed from the will, who needs to be added from the will. So always making sure that it's front of mind if things change, if you buy more assets, if you plan to travel overseas, if you've got assets overseas, you know, what is it that you need to change? And thinking about looking back at the will, is this still what my wishes will be if I was to go? And what next? So I guess it's up to you to really have a good think about what you would like your will to look like. So this is your story. This is your story around who is important to leave your legacy to and what legacy you want to leave to. So it's actually quite an enjoyable step to take, is actually, you know, going down and really having a think about actually everything that you've got and all those people important in your life. So yeah, and we're always here to help.
Thanks, Natasha. So that's covering off our will side of things. What we want to talk about now is the big decisions while you're still alive. And I'm just going to quickly go over this because I'm conscious we want to allow time for questions and answers. Just going to give you a few reflective questions to just think about, and then I'll explain the relevance at the end of each one. So how many of you have taken a walk for a location to lunch or gone for a motorbike ride on a Sunday? How many of you have gone on holiday and gone and done that exploratory touristy walkabout? How many of you have done building or renovating in your own home and stood up on a sawhorse? I know anti-health and safety, but some of us have, or on a ladder. How many of you have a morning routine when you wake up, such as you get up, you may use the bathroom facilities and then have a cup of coffee in the morning? If you've said yes to any of these situations, enduring powers of attorney are important for you. Now, I said to Ellen, when I say these ones, I start to sound like I've got an accident-prone family. But I do have a big family, and it's just that with my role, I seem to get involved with these things. So if you've walked or gone out to lunch, come home from a luncheon. So my lovely grandmother, she was returning home from the Anglicans woman luncheon, and unfortunately she was on her mobility scooter and a car came out of the driveway blinded by fencing and growth and sadly backed straight into her. Now she fell off her mobility scooter and the force of the hit of her head hitting the concrete did that she did permanent brain damage. And unfortunately, she didn't recover from that side of things. So enduring powers of attorney were invaluable for my family. Tourist walkabout, and my client is more than happy for me to share her father's situation. Her father had gone for a walkabout and just as simply slipped on the gravel. And unfortunately, he became permanently paralysed and was unable to sign documentation. Standing on a sawhorse or on a ladder, a good family friend of ours, unfortunately, he was standing on a sawhorse and he fell straight onto concrete. Similar situation causing paralysis and extensive time and rehabilitation in Burwood in Christchurch. And in the morning routine, in the morning to go to the bathroom and get up in the coffee like most of us do, did you know that the most common area for a person to collapse or have a heart attack or a stroke is actually in the bathroom? So each of these situations are relevant to somebody, whether you're young or old. A lot of people think enduring powers of attorney, I'll get them when I'm elderly. It's not, it's for everybody, any adult. An enduring power of attorney means that information, decisions and actions needed could be made immediately without the delay of court proceedings. So just to extend on that, an enduring power of attorney, when we're talking about that side, an enduring power of attorney for property is anything other than your body. Who makes the legal and financial decisions for you? A next of kin doesn't have legal right. You need to have nominated who you wish to make decisions for you if you're not able to do so. An enduring power of attorney for personal care and welfare, that's talking about your body. Who makes decisions for you? Again, with those options, with personal care and welfare, you can appoint an individual person one at a time. With an enduring power of attorney for property, you have the option of appointing an organisation such as Public Trust if you feel that you'd much rather a professional organisation or a trusted person or persons. There's a variety of ways that you can do it, and our online service and our trustees can guide you through that. What happens if you own joint property? People say to me, look, I own everything jointly. Well, even if you own your house jointly, you can't actually sell. If you needed to sell the house to be moved closer to where your partner or spouse is rehabilitating, or you might want to move to a more mobility friendly house or something like that, without an enduring power of attorney, you cannot sign on their behalf and you would have to apply to the court. Equally, as I mentioned, next of kin does not give you natural legal rights. So the things called the Privacy Act, such as the Privacy Act means that you need to have a personal care and welfare attorney so that your loved one can be involved in decisions about your health if you no longer have that ability to convey your wishes. If you don't have an enduring power of attorney, it is a lengthy and documented process through the court. There's an application made to the court. It's referred to a judge. A judge appoints a solicitor to investigate on behalf of the incapacitated person. The judge considers the findings presented by the solicitor. If they agree, they authorize the appointment. If they identify issues, they will summon there's disagreement, they will summons the parties relevant to discuss before making a decision. And with property appointments through the court, whereas an enduring power of attorney, as the word says, is enduring, the property appointment is reviewed regularly by the court and no greater than periods of 3 yearly. So the appointed person has to submit statements of account to be audited by the court, and coincidentally, Public Trust is actually the appointed auditor for that. If there is an objection to the appointment, then investigation, mediation, hearing and judges' decisions can all be involved. This all takes time, documentation, costs, and can be very stressful. Bills aren't being paid, or somebody might be having to finance situations over that period of time. I was recently involved in one and it took well over a year, and that was even in the situation where the loved ones were actually all in agreement with the appointment. It just took a long time. A little handy statistic as we're rounding out these side of things is life expectancy has doubled in the last 200 years, and the average years of a person from the age 12 now is expected to be over 100. Statistically, it's clear that we're all living much longer, and part of this means we need to put in place provisions to ensure that we're looked after and represented by the people that we feel are best representing our wishes, our interests, if ever we're not able to do so ourselves. Age Concern reports that approximately 70% of our elderly people's abuse, that includes financial abuse, is caused sadly by family members. So you need to make sure that the right appointment, the right person or organisation, just like your executor and trustee, the person that or the organisation that has the time and the experience and the ability to act effectively on your behalf. So that's a very quick whip through on enduring powers of attorney. The team at Healthcare Plus are going to provide you the link for more detailed information from our website, which you're very welcome to get. Just before we move across to Alan for question and answer, we're just going to play a brief clip on our online services, and then we're going to pass over to Alan. So thank you very much. Please feel free to contact the team. We've got, as Natasha mentioned, we have a variety of ways that we can contact you, whether in our customer centre, online, and we have a great 0800 number and telephone service as well available for you. And we're going to hand over to Alan now, who's going to go through the questions that you raised prior to the seminar.
Thank you, Carissa and Natasha. That was very interesting. I mean, I guess to summarise, it really is key to get your wishes down on paper and to get it down on a will and to get it lodged and to make sure it's updated so that you don't have to go through the courts if it all, you know, if you die without one. I mean, I guess that's the key one. It looks to me like, you know, there's 3 laws out there that cover things, but you know, if you want the law, if you want lawyers, you want judges to be making decisions, then that's one thing. But the key thing is, if you don't want the lawyers and judges to be making those decisions, is to get that will. And then with EPAs, blooming heck, you better just get one now, because you never know what's going to be happening around the corner, particularly if you're hanging out with Carissa's friends and family. So yeah, so EPAs, it's definitely something that we need to think about. And I guess the other one is, you don't have to be an old person to be thinking about an EPA. It's probably a good idea to get into that sooner rather than later, particularly if you've got kids and stuff. Hey, look, we've had quite a few questions. We've got about 5 or 10 minutes. And so were a couple of questions that came through on the chat, actually. Quite a few of them were around prices and prices for this and prices for that. We'll cover off that later. Post this webinar, we'll send out a whole lot of information around how much it'll cost if you want to use a public trust for any of their services. Certainly, I used the online will service recently, and it was really, really quick and really, really cheap. And I got my discount as well. So I'm a fan. I think it's really good. And I was one of those people who had done a will 10 years ago. And I think there's some of the questions back there around, you know, I did my will a long time ago. Is it still valid? well, it's only valid if it's still the wishes that you want to happen now. And if your wishes and circumstances have changed, like mine had, then you've really got to make sure you get it changed. So let's go through some questions, Carissa. I hope you're ready.
Go for it.
The first question I've got here is, does the way you own an asset impact on the estate administration required?
Yep, that's a good question. So if you own something jointly, there's different ways you can own something together. You can own it jointly, or you can own it tenants in common in specified shares. If you own it jointly, it transfers by survivorship on the death of the first person. So quite often you just need the death certificate for like a bank account, and you can get it transferred in your sole name. If you own it tenants in common, a specified share, whether it's 50-50, 20 and 30% and 50%, whichever one it is, then that if that asset that you own, that percentage that you own is worth more than $15,000, you will need probate and the legal process to do it. If the assets are owned under a family trust, then it doesn't form part of the will. There may be some directions pertaining to the family trust in your will, but that's an individual thing. Anything to do with family trust, would really, really encourage you to have a chat to our trustees about it. That's quite individual. And then the other one I just wanted to quickly mention was, it's really important to make sure with your life policies, I think Natasha referenced a bit of life insurance there, have a check who owns your policy. You may be the life that's insured, but are you the policy owner, or have you named somebody else? If you are the policy owner, it goes in accordance with your will. If you've named somebody else to be the policy owner, it doesn't form part of your will, it passes straight to that person upon your death.
Cool, thank you. Another one is, what information and documentation should we be including with my will records?
That's a good question. It can save a lot of time and a lot of money, and probably a lot of stress. One of the biggest worries that we have when we're administering estates and we first have that initial contact is making sure that the property is insured and the bills are paid. So what happens when you pass, as soon as the bank is notified that you've passed, they stop all the direct credits and automatic payments. So one of the biggest worries for us is knowing where your insurance is and making sure that it's current and up to date and paid as soon as possible to secure that asset. An executor and trustee can actually be held liable for not securing assets. So it's really important that we know where that is. Same as with your life insurance, shares is another one that's really hard for us to sometimes track down. Do you have shares? Where are they? Or is there a share manager that you do it? Another one these days, because the phone book's no longer valid and Facebook can be a little bit hard to stalk people through because there's so many of us. Contact details of the people that you've provided for in your will, not just their address, but have you got like an email or a cell phone number, which is more likely what they'll carry through. Natasha, was there any other ones you thought of? That was just my quick vital ones. Bank accounts, who your power provider, all those sorts of things are kind of the obvious ones, but they were the critical ones that I came to mind straight away.
Yeah, any changes in funeral notices or how you'd like your body to be at the end of things? Yeah.
If you've prepaid it with somebody, who's that with? Yeah.
Okay, cool. There's a couple of ones here. I'm going to read one from the previous the questions before the webinar, and then there's also a question that came up in the webinar which seems similar. The first question is, I have assets overseas. What do I need to consider? And then the question that came up in the webinar was, if we have already made a formal will abroad, obviously in a different legal framework, what is required, if anything, to update to a New Zealand context, assuming all the background intents and assets have not changed?
Another good question. So overseas assets, so often it depends on where it is. Sometimes it can be easy. For example, Australia side of things, we've got some great contractors that we work with there. But quite often, for example, a key factor I find, if you've got a property elsewhere, I'd really strongly encourage, if it's possible for you to have a will related to that country, it can be really useful and be more cost effective that way. If not, then what we want to do is be very clear of what you do have overseas, because we want to be clear in the will, does this will relate to your New Zealand assets, or any assets anywhere, or does it exclude a specific country? But I'd really encourage that if you have got assets, to have that conversation about overseas ones. If you've made a will already, as the one in the chat referenced, if you've made one elsewhere and you want that to still apply, which is probably quite relevant and a good thing to do, subject to what is its content and if it's current, but then you could do a will in New Zealand that's only pertaining to your New Zealand assets, or any assets excluding whatever the country was that you apply. So you'd want to bring in that will so that we could look at that and make sure that we were not doing anything contradictory. We do find, you know, that, gosh, New Zealand is a wonderful multicultural area, and, you know, we can find, for example, like we deal with Thailand recently, things like that. So if you also have contacts of legal firms that you have worked closely with, we'd love to know those sorts of things as well, to hopefully make it easier. Again, takes time, cost and money. Every country has very different processes. So it's so important to actually make sure what you've got when you've got overseas assets, to make sure what you've got is current and very specific as to whether it includes or excludes.
Couple of quick questions. Do I need a will if I only have a KiwiSaver?
KiwiSaver, same applies. It's an asset in your sole name. If it's over the value of $15,000, yes, you do.
Okay, and you would put that in your book.
And you know, bearing in mind, KiwiSavers quite often grow. So again, you might as well have something nice and simple and straightforward in there. You know, the cost of doing a will is always better than not having one.
And another hopefully quick question, does the will get read before the funeral? I thought it would be later.
It's a good question. You know, I think probably from American television, people still perceive that there's a formal, you know, everybody comes into the office and we announce the will. Quite often, to be honest, I've been 27 years, it's not often that happens. Usually the family members have found the will or know where mum kept their documentation or dad kept their documentation. And again, everybody's spread about. So when we're involved, what would happen is that if we were contacted and notified of the passing of somebody, or that we saw a death notice and said, oh, this is a client of ours, which is what we do, is we search, we have a team that search the death notices to make sure any clients of ours are identified, and we make contact with the family or the loved ones or the beneficiaries. We identify the beneficiaries, we validate their identity, and then as long as you're a residual beneficiary of the will, after the passing of the loved one, you are entitled to it. If you are not named in the will, if you are only receiving a gift under the will, you are not entitled to the full copy of the will. You are only entitled to what was specified pertaining to you. If you're really interested, if the document was if the will was probated, you know, once the estate administration was applied, you can actually apply to the court to get a copy of a probated will. That becomes a public document, but we will not release a copy of a will unless you are a residual beneficiary.
Okay, and I've got two questions here about Maori land. So one says, what happens with Maori land? And then the other question, hopefully Tui's still with us. My late father's interests in Maori land were not fully succeeded to, so he still appears as an owner on Maori land, court records, and public trust for the executor. My question is public trust able to manage these interests better in the night? Oh, I think I'll pass that one on to you guys directly. So yeah. Anyway, the original question is what happens with Maori land?
So with Maori land, the Maori land court has, if you, maybe we can pass perhaps Dora on the link to that, have a wonderful website, and they actually have their own process by which you're followed. So the vast majority of the time we're not involved. What can happen is we're contacted by the land court or the whānau to say, do we agree with the land court proceeding on with the matter? Sometimes that's required from us, but vast majority of time that's the limitation of our involvement, because they have their own legislative provisions. They've got a great website. The courts, if you're not accessing, I'm assuming because Zoom, most people have access to that. Otherwise, the courts do have brochures on that side of things as well.
This next question is, I have an old will 10 years old, 10 years ago. Can I update it online, or do I need to create a new one? And what happens with the old will?
Yeah. So in my early years of typing wills, we did do the whole codicil thing. We don't do that now. These days, because of technology, it's far better to just draft your will in your entirety. Otherwise, you're looking for bits and pieces and hoping that they link up together, particularly if you're going to do the wills yourself. So your will is done from completion to end is what we would recommend you're doing it in its entirety. What happens to your old will? In your will, again, if you're making sure that you have a professionally completed will, then one of the first sentences that it will say at the top is that I revoke all other previous wills. That's quite an important one. Just a little aside I'll mention on that is that for wills, you can put in your next will, I revoke your will. For enduring powers of attorney, it's not the same. If you want to remove someone from your appointed power of attorney and you have capacity to do so, you must do that in writing to them. You cannot just make a new document. So it's quite different.
Okay. Right. Well, we're almost at 5 o'clock. Let's see. We'll maybe try and get one last question in. I've been told to transfer all your assets, houses to your kids so that the government can't take it if you go into care. Is that a good idea?
I hear that one so many times when I do community speaking. So I know what people are saying. Oh, hey, if you put it into someone else's name, then you're not going to have any estate administration costs. If you go into rest home care, then they're not going to take it in rest home care subsidies. That seems nice in theory. In my experience, you're kind of playing, I guess, a game of poker insofar as you're assuming that things are going to work out the way you planned. And my experience is they don't often work that way. You don't know how long you're going to live. You don't know if the relationship with the person that you've transferred it to is going to still be the same. You don't know what's going on in their lifetime. You might have transferred assets into their name and their relationship breaks down and the person claims part of that, and there goes the roof over your head. Or same as when you're looking at building a house, mum's building a granny flat, or combined properties. You've just got to be so careful, and it's much better to have professional property sharing agreements, getting that comprehensive advice rather than having a go at maybe doing a bit of DIY approach. It can go terribly wrong, and you can be left in a situation where the assets that you worked incredibly hard for and to provide for you in your retirement are no longer there. So it's not something that I would be comfortable in encouraging, and I'm sure Natasha would be the same there.
No.
There's plenty of other discussions that you can have.
And
Okay,
also
well,
WINS have criteria, so they'll look back and they'll be able to see when you did transfer and whether it does fall into the criteria or not. So their website tells you lots of information too.
Yep.
Okay, so I think we'll end the webinar on that today. So thank you again, Carissa and Natasha, for your time and all of that useful information that you've provided over the last hour. To everybody that's asked, yes, there will be a copy of this webinar given out to everybody who registered. So whether you actually watched it or not, we will send a copy of that of this webinar to you all early next week. Also, for all the questions that we didn't ask, we'll put together a blog article with a whole lot of Q&As, and we'll get some answers to some of those questions as well. And that will follow on from the webinar too. And we'll also provide a whole lot of information around the questions that are specifically around sort of public trust costs and things like that. We will also send that out to everyone over the next week or so. So once again, thank you very much to everybody for turning up this evening. I hope you got something out of it. I hope you learned something about wills. I hope to the 66% who said no, they didn't have a will, they're already looking up Public Trust's website to do their will online. It's a good tool. Someone like me can use it. Anyone can use it. So it was very good. So anyway, thank you again, Carissa and Natasha, for your time, and thank you everyone else. Good night.
Thank you.
Thank you.